All right, and we are live. Welcome back to Immigration Compliance Corner. Today's topic, what actually happens during an H-1B audit and what's changed in H-1B compliance that most employers don't know about yet. So my honest answer is that in the past year, a few significant changes have taken place. So stick around all the way to the end to learn about what's been happening and how enforcement has changed related to the H-1B visa. Welcome back. My name is Emily Brown, founder and principal attorney of Elevate Justice U.S. Immigration Law. We're a private law firm specializing in immigration compliance and federal litigation. And we come live to you every Wednesday with Immigration Compliance Corner to talk about the latest topics in immigration compliance. So I-9 and E-Verify, or visa-specific compliance like we're going to be discussing today related to, for example, the H-1B program. Before we get started, as always, everything that I'm sharing today is for educational information only. It is not legal advice. Immigration law changes frequently, so for guidance tailored to your business, be sure to consult a qualified immigration attorney. Okay, so there's a few things before we get started. When you are filing for an H-1B visa as an employer, when you are the petitioner for an employee, you're always required to have and maintain a public access file for that H-1B petition. You might be familiar already, especially if your employer does have quite a few H-1B employees. So it's not optional, and I'm going to go over some of the basics of what should be included in a public access file or a PAF. The PAF should always have the LCA, the rate of pay for the H-1B worker, description or summary of the actual wage system, the prevailing wage and its source, documentation that the notice requirement was satisfied, a summary of benefits offered to U.S. workers and H-1B workers, a list of entities included as a single employer, and then there are additional requirements on top of that in the event of a corporate change for the successor entity that's going to then be taking over the responsibility for the H-1B worker. When it comes to H-1B compliance and investigations, you need to think back to the basics of how you file an H-1B visa. So first, you do the registration with USCIS now, but after you've been selected for the H-1B visa, or if you're filing a change of employer or some sort of amendment, you file the LCA with the Department of Labor. That is the first step. The second step is then filing the I-129 petition with USCIS. So this is a visa where you have two government agencies involved, DOL and USCIS. And both agencies have enforcement authority when it comes to compliance with the H-1B regulations, and both can conduct audits of the H-1B petitions. So let's go over USCIS first. Its benefits, integrity, and they're trying to see if it's a real petition. So the enforcement takes place with FDNS, the Fraud Detection and National Security Directorate, and they can do a few different site visits. So the first one is administrative site visits, and that can be generally random. Sometimes it could also be based off of worker complaints or different coordination with government agencies, but it's an administrative site visit that's usually generally random. The second type of visit is a targeted site visit, and that is going to be a more data-driven approach, according to USCIS, to verify the petition. So more background's happening within the government, and that petition's being probably targeted for a specific reason. USCIS, when they're auditing your H-1B petition, it's going to be a site visit normally in person, and they show up unannounced. So what they're going to do is they're going to ask for the PAF to review it to make sure it has everything that's required. They could potentially try to interview anyone with knowledge of the H-1B petition, so the employee, other workers, the manager, HR. And essentially, they're going to be looking for a few things. They want to verify that the H-1B worker is working at the actual work site listed on the petition and the LCA. They may also request payroll records to ensure that the worker, the H-1B worker, is being paid the proper wage from the petition of either the prevailing wage or whatever was listed on the LCA. And they also want to make sure that the H-1B worker is performing the duties that are actually listed on the H-1B petition. When USCIS does come for a site visit, it's generally voluntary, but if your company doesn't comply or fails to cooperate, that could actually result in revocation of the H-1B visa. So it's definitely something that you do want to cooperate with to ensure that the H-1B visa is not revoked. And you can always get ahead of these by ensuring compliance at the onset of when you're filing the H-1B, making sure your PAF is prepared properly, and then monitoring ongoing compliance to ensure all of the requirements are being met with the H-1B petition. Okay, so now moving over to the Department of Labor, DOL. DOL is really it's more of a worker protection type of audit, and they're looking to see, are you paying what you promised, essentially. So from DOL, it's likely going to be Wage and Hour, WHD, that will be conducting the investigation. And the same things, they're going to be looking to review the PAF, proof of the LCA posting, which should be in the PAF. They're going to verify wage compliance, worksite verification again. And then they could also be even checking to see if US workers have actually been laid off and then replaced with H-1B workers, because part of DOL's more broad directive is that they're there to essentially ensure that US workers are not losing opportunities unfairly. So that is something that they could be looking into. So essentially, when it comes to these types of audits, you have two agencies with authority. You have DOL and USCIS, and they have potentially different outcomes. So USCIS, as I mentioned, failing to comply could result in revocation of the H-1B visa. On the DOL side, if they do find any issues in the audit, you could be ordered to pay back wages, and there could be civil fines. So there's a different set of consequences that could come out of a DOL audit. Also, it's important to note that there have been cases where the agencies both audit the same employer. It's not like you're just going to be audited by one and then you're safe from the other. They could absolutely come and both of them audit the same company for the same H-1B petitions, especially if there have been issues that were identified. All right, in 2026, however, H-1B enforcement, the landscape is changing and it is becoming more aggressive. So this current administration, it is a stated priority that they want to crack down on H-1B visa fraud. So in late 2025, you may have heard that they announced Project Firewall. This was an initiative of the Department of Labor, and it's essentially the Secretary of Labor is going to now be able to personally certify investigations, which is pretty significant in the history of H-1B audits. DOL is coordinating with DOJ Civil Rights, the EEOC, and USCIS. And so this essentially means that there's going to be more audits based on information sharing and data sharing within the government. So it could be more of a targeted audit. And again, consequences from these audits could be back wages, civil penalties, and then even debarment. And debarment means that the employer is found non-compliant with the visa program and they're not allowed to file for that particular visa worker or like H-1B visas in general for a certain amount of time. So if you're a company that uses a lot of visa workers, that's a really significant consequence that could come out of an H-1B audit that it's if you're not complying with the regulations, it could be really serious and impact your operations. So this Project Firewall is a noticeable shift because the secretary certified authority means that DOL can open a case on its own without worker complaints, for example. So it could be more targeted. And while this authority has generally existed, it's not necessarily been used in this way before. So it is a shift in enforcement, the way DOL is conducting H-1B enforcement. The other big update that happened was actually this past July. DOL's Office of the Inspector General announced that it's going to increase enforcement as well. And this is actually going to be enforcement in a criminal capacity. So they announced a formal investigation into H-1B and perm fraud, and they framed it around doing forced labor and human trafficking investigations. And so it's going to be running alongside a federal task force. There's also an active public hotline, so they could be doing investigations based off of anonymous tips from the public. And again, they could be also soliciting reports from displaced U.S. workers. So it could open the door for more coordination from displaced workers who feel like they might have been facing a disadvantage in the workforce due to certain visa programs. And as mentioned, this is a criminal investigation built to refer for prosecution. It's not just a compliance letter or an order to pay back wages. So I hope this was helpful. There's 3 things to take away from what I'm explaining today, and The first is that your PAF, your public access file, it needs to be built to survive an audit. It's not just a checkbox of like, yeah, I have it, and then you set it over to the side. You need to ensure that it's built to survive an audit and survive government scrutiny. Second, USCIS and DOL, they could be doing audits and they're looking for different things with different potential outcomes and consequences. And clearing one audit doesn't mean you're not going to be potentially on the hook for a different type of audit. And just a reminder, 2026 is not 2023. Enforcement is a stated priority. And now there's more coordination within the government doing data sharing, bringing forth more targeted audits with FDNS, wage and hour, and DOL OIG. So it's something that if you're not sure where your H-1B program stands, to definitely work with an immigration attorney to make sure you can bring yourself into compliance. So if you're running through your PAF, your public access files in your head right now, and you're not really sure where you stand, that's exactly where I help employers work through. I support employers going through government audits related to visa-based programs, and I also help companies implement strong compliance programs built to withstand this government scrutiny. So please feel free to DM me if you have any questions, or if you have questions, feel free to drop it in the comments below. But okay, this wraps it up for today's Immigration Compliance Corner. My name's Emily Brown, founder and principal attorney of Elevate Justice U.S. Immigration Law. I will see you next week, same time, same place. Like I said, feel free to DM me any questions